I think my story is probably similar to a lot of people. I went to law school never intending to practice law. I remember my roommate in law school went to law school because he didn't know what else to do. And along the way, I had a job waiting for me in corporate life. And along the way, we had that moot court competition that everybody had to participate in law school. And I ended up a finalist. I got to argue in the nationals next year. Next thing I know, I must be a litigator. And had a wonderful opportunity coming out of law school to work in big law, in litigation, where I learned a ton. But one of the most important things I learned was that just wasn't personally fulfilling for me. And I really wanted to represent people. I really kind of craved the David versus Goliath opportunities that this type of work provides.
Welcome to Between the Briefs, a podcast by Steno. We're here to bring you practical tips, expert insights, and real conversations about the pretrial process, court reporting, and the legal technology shaping the future of litigation. I'm your host, Adrian.
And I'm your host, Joe Stevens. Whether you're an attorney, paralegal, or just curious about how technology is changing the legal industry, we've got something for you. Each episode will break down complex topics, share behind-the-scenes intel, and talk to the people leading innovation in and out of the courtroom. So grab a coffee and let's get into what's happening between the briefs.
Hello and welcome to Between the Briefs, brought to you by Steno. I'm your host, Adrian.
And I'm your co-host, Joe Stevens. Today we're joined by Eric Weitz, the founder of the Weitz Law Firm. With over 30 years of experience in litigation, Eric has built a reputation for his dedication to representing clients in catastrophic injury and medical malpractice cases, focusing on achieving justice while improving safety standards. His work is a blend of strategic trial advocacy, client empowerment, and community impact.
Eric also serves as the president of the Pennsylvania Association for Justice, where he advocates for a fair and effective justice system. His vast experience in complex legal matters, combined with his passion for safety and justice, truly sets him apart in the legal field. Eric, welcome to the show. It's an honor to have you with us here today. How are you?
I'm doing great. Thank you, Adrian and Joe, for having me on. This is a wonderful opportunity. How are you guys?
Of course. We're really happy to have you on. So let's just kick off the conversation right from the beginning. Tell us what got you started in law, especially, where you're at now with over 30 years of experience.
Yeah, I think my story is probably similar to a lot of people. I went to law school never intending to practice law. I remember my roommate in law school went to law school because he didn't know what else to do. And along the way, I had a job waiting for me in corporate life. And along the way, we had that moot court competition that everybody had to participate in law school. And I ended up a finalist. I got to argue in the nationals next year. Next thing I know, I must be a litigator. And had a wonderful opportunity coming out of law school to work in big law, in litigation, where I learned a ton. But one of the most important things I learned was that just wasn't personally fulfilling for me. And I really wanted to represent people. I really kind of craved the David versus Goliath opportunities that this type of work provides. And, I had an opportunity to join the Plaintiff's bar in the greater Philadelphia area and the Commonwealth of Pennsylvania. They call it practice. I'm still trying to learn how to try cases. I don't know how many I've tried, but it's been a wonderful journey, which has then now led me to predominantly doing catastrophic work.
Eric, I'm a lawyer as well, and I teach at a law school here in West Texas. And I love the fact that you're talking about the things that you're still learning now. There's a humility there, obviously, but I'm wondering what that is. What are the things that this deep into your practice still surprise you, or you're trying to work on and improve?
Yeah, I look, whether I'm on trial and something happens where an opportunity, or you see something in your daily practice, I call them gifts. It's the way I choose to label them, because I really view them that way. It's not, oh my God, how did I not know it? There may be many reasons, but I also teach. I teach some trial advocacy courses at a law school in the Philadelphia area. And last semester, we just had an interesting kind of case scenario, and we were doing depositions. And the way some of these young women approached an issue, that it was a sexual harassment case and everything, was so eye-opening to me and so revealing to me about how my own biases, my own maybe generational issues and everything kind of really reminded me that we always have to take a second look when you're trying cases for a living about not just how we used to relate to people, but how we can perceive ourselves relating to them now. So it's everything. I mean, you learn something substantive, but there's this old saw that, oh, you have to have tried a whole bunch of cases and you know everything. Newer people with fresh ideas is unbelievably valuable, especially in a world where jurors in their regular lives, social media, the internet, streaming, everything, are receiving information in a much different way than we were used to in the way I was taught to try cases 30 years ago.
That is the truth. And one thing I love about your experience is your everything you've done in trial law. Now, it's one thing to take on a case, work on it, and a complete other to be in the courtroom and actually work a courtroom and a jury and understand how to present information correctly. What is one of your biggest tips you would have for any attorneys really striving to be in the courtroom, speaking to a jury? What is one tip that really helped you succeed in trial law?
It's not profound, but it is so true. And so many teachers say it. So this is not novel coming from me, but authenticity. Authenticity is the single most potent weapon that anybody has. And that means everything from the fact that when you find your own voice, it's not going to be like that other person who had an amazing result or did something incredible or was able to turn something around. You're not going to be that person, but you are who you are. Jurors are really good at sniffing out nonsense. And if you're trying to sell something in terms of a theory and you're not being genuine as a person, it doesn't matter what you say. It doesn't matter how right you are. So I think the number one most important thing is to find a way to be comfortable in your own skin and be authentic, be who you are. You don't have to put on a show. You don't have to be nasty. There are times when maybe it's warranted, right? But A Few Good Men is a great movie and it's an incredible courtroom scene. But, in real life, it kind of comes off as being a little hokey.
Eric, do you find that hard to teach? And if not, what do you find hard to teach the sort of emerging generation of future lawyers?
Yeah, I kind of feel like all those folks I hated when I first started practice would say, "You guys, I remember what." Two things that kind of strike me right off the bat. I hadn't thought a lot about it. Is number one, there is an absolute lack of ability to communicate in writing. I don't know whether it's the proliferation of text messaging and informality in emails, I don't demand nor desire formal writing when people communicate with me. But when you're filing something with a court, you're trying to convince somebody, like the ability to write persuasively without a lot of adverbs and adjectives in a very coherent way to get your point across to multi-generations, because you're often speaking to a judge and to a law clerk, right? It is really important. And I think that's become very difficult to teach because writing styles have just changed. I don't want to say deteriorated, but changed. The second thing is I used to be convinced when I was younger that to be a trial lawyer, you had to have that it factor, that sense of presence, that sense of knowing when to turn drama on and off and being able to think quickly on your feet and everything else. Until I'd spent enough time in a courtroom to see all sorts of different styles in what resonates and everything else. I think though what's difficult to communicate is how to be persuasive, because the dramas we see today in media, even in the newspaper, even on the news, right? The drama we see today is so exaggerated and so overblown. And I have just found that doesn't translate well into a courtroom until the client or the lawyer have earned it. In other words, something has happened that they need to step it up a little bit. But these, you go to some of these seminars and these people talk about, look at the opening I did in this case, and they've got fireworks and drones and like all this nonsense going on. And I just think people, they expect something different. They expect drama. They watch CSI. They watch all these shows. right? I always say, I can sit down, I can see the crime, I can see the investigation, I can see the trial, I can see the resolution and the aftermath all within an hour. Why do my trials take so long, right? But people do want it quick. They do want it clean. They do, want some sort of drama. But trying to teach people how to deal with the real life drama that exists in the courtroom without it being boring and without being over the top. I think, that's a nuance. And I don't know how you teach that without just, I was a junkie. I used to go watch other people on trial all the time just to see how people would handle different situations. And it's hard to do that, especially as a young lawyer now with all the demands.
Makes perfect sense. And I'm curious, we've had plenty of attorneys on who I've heard it time and time again. I went to law school, but it didn't really teach me how to be a lawyer, right? How to be in the field, get the job done, the business side of law that you don't expect. Where do you think the disconnect lies between what you learn in law school and when you actually get real world experience as an attorney? And how do you think there could be a bridge between that divide?
Yeah. So there are a number of law schools who are starting to address that. One of our local law schools in the Philadelphia area has been in front of that from the beginning, right? I think look, what are you going to law school for? You're going to learn how to think, and then you're hoping to pick up some substance to help you on the bar exam, period, right? It's still, we're teaching to the exam. Certain types of law schools have different bents, they have different philosophies and everything else. They talk about more theoretical stuff, but at the end of the day, you got to pass that test because otherwise it's been a nice 3 years, but now what are you going to do? Right. So I think that I think law schools can't get out of their own way in that regard. I mean, it's one of the reasons why I'm working in my alma mater to help try and stand up a better trial advocacy program. It's a law school that's very focused, old school, traditional topics. Okay, we want to turn out transactional lawyers, which is fine, but there are a lot of kids there, like me, who want to learn the stuff. And I always used to say, it'll kind of date me when I came out of law school, but they should teach you how to fix a copier, right? And how not to get toner all over yourself, right? I mean, I think they should teach that in law school because the number of fights I had at 2 a.m., in the copier room back in the day, now they need to teach you how to market, how to communicate, what you can and can't say. What does a trust account really look like, and what does it take to maintain it? And oh, by the way, what does networking look like, and how does that work? And not everybody's going to do it, but I still think law schools, very much care about their bar passage rate and everything. And since the bar is the threshold now, that's why I think our education is so limited, and you only have so many hours. So how many courses can you take anyway?
Yeah, that rings true. I mean, I feel that in my world as well, Eric, and I think it's always interesting to see how these skills are taught and how they also just need to be, you just need to get on your feet at some point and do it. I want to ask you about Pennsylvania Association for Justice, because I've spent the last 6.5 years in rural Texas building and running public defender offices. And my law school is the only one in the country that has one inside it. And I teach and run that office as well. So that matters a lot to me. And I'm wondering what that actually means to you. What does this association do? And what is in its crosshairs? What's its biggest mission driver right now?
It's interesting you say that. We're in interesting times. So we are, I think by most reports, the preeminent statewide trial lawyers association in the United States. We have about 2,000 members. We have been incredibly successful on the political front in terms of fighting back countless initiatives that prevent access to justice, whether it be in the form of a jury trial or other impediments to folks having their day in court, due process, things like that. We also have a robust amici program where I think we were involved in over 20-something decisions by the Pennsylvania Supreme Court last year as amici. And I think we were on the winning side, like 22 of that. we are deeply invested. We're 57 years old. We are deeply invested in the fabric of the judicial system and the legal system, the justice system in Pennsylvania. What it means today, where our priorities are, in order to become president of our association, you have to serve all the line officer positions. So it's a 7-year journey. And I can tell you the things that I thought were important 7 years ago when I started, 5 years ago as I was working my way up, 2 years ago, are not what I ended up having to address when I came into office about a month ago. I stood up at our annual meeting and our dinner, and I talked about what I think you're alluding to, Joe, which is we are probably facing the single greatest attack on the rule of law and the independence of the judiciary that we have ever seen since probably going back to maybe the Red Scare or some, 30s, 40s. It is terrifying what's going on. It's terrifying what's going on across the country, overreach by the government. And I, like many other people, have a lot of concerns as to whether our courts are going to have the backing and ability to stand up, because they, our federal legislature has kind of abdicated their power to the executive branch. The courts are all that's left. And when I talk to colleagues of mine who are now on the bench in Pennsylvania, whether it's appellate courts, or trial courts, or even talk to other people I meet on the judiciary, whether it's federal or state, the threats on their family, the threats on their lives, the attacks in the press because somebody doesn't like an opinion, even though it might be 100% right on the law. We forget judges are human beings too, and we want them to be impartial. We want them to be fair. But we're kidding ourselves if we think all of these attempts at intimidation and threats are not impacting their ability to do their job. And look, if we want to decide as a society the rule of law is not that important anymore, then let's all grab our baseball bats and let's head out into the street and solve our problems that way. But if we kind of believe that that is a fabric of being American, we have to stand up for it. I don't care what party you're in. And that is probably one of our biggest driving forces right now for the Pennsylvania Association for Justice, because we have a very unique state, right? We have two big metropolitan areas in Pittsburgh and Philadelphia. And then we've got a lot in between, ex-urban, rural, suburban, everything else. We've got, the state has been purple. It's been going back and forth. So to find any political cohesiveness is very hard. There are Republican judges and Democrat judges, because our judges are elected and our justices are elected in Pennsylvania, who are under threat and under attack. And it really, their party doesn't matter, but their job does.
Would love to know, what would you recommend to any attorney out there listening who wants to get involved with their associations for justice? How would you recommend they take a step forward to have some kind of involvement?
20-something years ago, I was introduced to the then president of the Pennsylvania Association for Justice, and I met with him, said, tell me what you do. How can I help out? I think there's a perception in many circles that to be active in the trial lawyers associations, whether it's nationally at the American Association for Justice or in all the Texas trial lawyers, whoever it might be, is that it costs a lot of money and that you have to be willing. And look, there is a role for that in the process. It's political, unfortunately. But our association, and I've spoken to presidents of other associations. I've been around this world now for a while. We need workers. We need smart people. We need strategists. We need young people who want to get engaged, right? There's always something to do, whether it's meeting a local politician to talk about a topic, to introduce them to a client who a law would keep them out of court, or, a young lawyer to help research something for a big issue. There's always bills being proposed. We need people to look into that and say, what's hiding around the corner? Or where did this come from? Or what's the current state of the law? There are so many things that need to be done. We are so busy, and it's not like we're a huge law firm or huge corporation. We talk about, we have 2,000 members, so you've got 2,000 partners in your practice of law, which is nice for especially somebody like me, who's pretty much almost always practiced in a small environment. But it also, there's a lot of work that's going on in so many different facets of what we do, right? Whether it be workers' compensation, social security, private disability, medical malpractice, products liability, whatever it is, these are robust areas, and pretty much the only area left in our society where people can truly seek accountability.
Eric, how do you stand up to what you just described? I suppose my question is, I'm a member of the Texas Criminal Defense Lawyers Association. Our state is very different than Pennsylvania in some ways, and in other ways, there's going to be some overlap. It's a loud state. It's very rural. It's got its urban centers. But from a defense bar point of view, that there seems to be an overwhelming amount of solidarity, right? I mean, we're stepping into courts, whether they're in rural sort of or urban settings. We have similar issues. Sometimes they are different just by nature of geography or whatnot. But I guess my question for you is, are you seeing a lot of solidarity among the plaintiffs' bar on these issues? And are you seeing a lot of solidarity or getting a lot of pushback from them when it comes to, okay, let's be unified on these fronts? How do we do that? Or is there division amongst the bar as well?
Right. It's there's a saying I've heard in many different contexts: if you want to destroy a group of people, leave them alone for 50 years, they'll destroy themselves. Right. So when you have a common enemy, you've got a common cause. I mean, they talk about nationalism and patriotism in the United States after 9/11 versus 10 years later. Right. I mean, you see it. So, one of the easiest parts of being president of the Pennsylvania Association for Justice is we are 57 years old and we've been under attack for 75 years, right? So, the rights of our clients to access justice, to, the attempts to limit the recoveries. We have a measure right now. I was just in Harrisburg meeting with legislators last week where they want to limit the ability of children who suffer neurologic injury during childbirth, limiting their access to accountability, right? Like why not brain damaged kids, right? I mean, who's going to speak for them, right? They don't have a lobby, right? And so when you see these attacks on the stuff, you kind of have to be, I don't want to say true believer, but you kind of have to have some kind of fundamental belief in the system to do what we do for a living. Most of us work on a contingency. If we didn't believe the process had some fairness, what are we doing? Right? Betting our own resources and time on 12 strangers down the road in a system that otherwise is not fair. So I think the nature of the cause is fairly unifying. Do we disagree on tactics? I always kid. I have the easiest job in the world. I've got 2,000 members and they all know everything. But sure, we differ on tactics. Sometimes we differ on nuance and everything. And Lord knows, right? 5 lawyers, 10 opinions, right? There's always robust discussion. But I think at its core, right, that however you define justice, there seems to be a common understanding. And so unifying folks is not hard in terms of the overall goal. The means we can argue about, but I think that's just human nature too.
Eric, I would love to steer the conversation towards the start of your firm. What led you to start your own firm and grow the Weitz firm to where it is today?
Well, COVID didn't help. But before COVID, I had an opportunity. I had practiced in a larger plaintiff's firm with a whole bunch of lawyers, amazing lawyers. With a terrific founder and everything else. And I kind of found myself running from trial to trial and case to case, where I had kind of been brought up in the plaintiff's bar that I was very hands-on. I was doing everything from drafting the initial documents, taking all the key depositions, doing what I had to do, including, grabbing, in the old days, my flip charts and going into the courtroom by myself. I didn't have people carrying my bags or, wasn't using technology and everything. And I kind of missed the relationship in terms of vetting cases, especially since I predominantly do medical malpractice. Those cases take a lot of vetting because there's a lot that could go wrong in those cases, even though it's probably malpractice, but in terms of actually winning it because of the vagaries where law and science overlap, it's not clean. So I had an opportunity, and I took it. I'm a trial lawyer. I love trying cases. I figured with the right kind of selection of cases and surrounding myself with a much more limited staff, I could kind of hone in on a fixed group of cases rather than a large volume. And I started growing, and then COVID hit. And I don't know the experience in the rest of the country, but in our region, if you had those kind of medium and smaller cases, the auto, the trip and fall, the other kind of, those were resolving and people were kind of staying open. In my world, in the big cat, nothing moved. Courts were shut down, especially suing hospitals. They were a little busy during COVID and they couldn't really focus on these cases, and I got it. And so things didn't move for a few years. So things stagnated. And now, a number of years out, we've been very lucky. Philadelphia has the single most efficient court system in the country when it comes to catastrophic injuries, especially medical malpractice. They get the cases resolved in about 2 years, which is, none of our surrounding counties, nowhere else in Pennsylvania gets that done. And I've practiced in many other states. You don't see that level of efficiency. So we've got an amazing bench, and we've got a bar that, we fight over what we should fight over, but otherwise, we pretty much work together to get these cases ready. And the nice thing is kind of who's left. And, I'm one of many, right? But who's left, like we all know, like all of us are willing to try a case and can try a case. Doesn't mean we have to or we should try every case, but you don't get a lot of, like I do some commercial cases here and there, and you get a lot of fighting over fighting because maybe somebody really doesn't want to go to trial because they haven't gone to trial in 10 years. Maybe they've done 22 arbitrations, but they've only seen 1 or 2 jury, right? In our world, like everybody's done it. Like you don't have to deal with that. We all know what's going to happen, right? We don't know what the outcome's going to be, but we know what a trial's like. So it just allowed me to grow. Plus, I think my niche in terms of preventable medical error, if you believe Johns Hopkins, it's the 3rd leading cause of death in the United States. There's unfortunately, enough work to go around wherever you are.
Eric, a success metric very commonly and maybe crassly can be purely financial when it comes to being a plaintiff's attorney. What is a non-financial success metric?
That's a great question, Joe, and thank you for asking. One of the things I have been pushing for almost my 20 years in leadership of the PAJ is what I call non-economic consideration. And it's one of the reasons I went down to Johns Hopkins and got certified in patient safety and quality care because I wanted to learn the other side. I got sick and tired of handling the same case over and over again, seeing the same mistake made and seeing families' lives completely ruined when it was preventable, right? Overwhelmingly, I think you ask anybody who's an expert in the field of patient safety, they're going to tell you, overwhelmingly, preventable medical error has an institutional causes to it. Right? It's very rarely the doctor holding the scalpel at the end of the line. It was the 20 things that went wrong that got to that point as well. And so I kind of wanted to look at it and see, boy, if I look at it from the other side, from the outside, can I bring a voice to it? I'm not going to solve the problem, but at least some insight to help. And in doing that, it made me realize that every client that walks into my office, and I would venture to say any lawyer doing catastrophic work, they always hear the same general 3 things. It may not be in these words, but they hear the same 3 things from their client. 1, they want to know what happened because when things went bad, nobody told them and they weren't given the straight story or given no story. Number 2, they want some level of accountability. And our system only provides a financial accountability, right? It's imperfect, but it's better than, an eye for an eye or something like that. And then finally, what they all say, and I've learned a lot more about this recently, is they want to make sure it never happens to anybody else. And there is very fascinating psychology behind that and why people genuinely feel that way. And I've always felt as a trial bar, we have been awful at fulfilling that 3rd desire for our clients. And so I will insist in almost every case where I sat down with my experts and we figured out what went wrong and why, at least the primary causes, that be fixed as a condition of settlement, not just whether it's re-educating staff, whether it's changing protocols, whether it's causing electronic medical records to send an alert when these things show up in the record, whether it be requiring somebody to check something off and do something else, not just check a button to make sure that a person's bed was checked, whatever it might be. It's gained traction. I got other people doing it. I'm not the only one. I've been doing it more and more, but it never ceases to amaze me that when I resolve a huge case, right? Forget the money. We can argue about the money. We will always spend more time arguing about the non-economic consideration. Sometimes it's a donation to a foundation. Sometimes, it's just purely education with some sort of accountability. Sometimes, I just resolved the case recently. The non-economic consideration was they had to conduct a full root cause analysis, which is the reliable scientific method for figuring out what caused something to happen. And they were complaining about how much it cost. And I said, I'll pay for it out of, you'll pay me more, my client more, and then I'll pay for it. And I don't even want the results. I just want to know that it happened. I mean, and we spent more time arguing about that than the financial value of the case.
That is incredible. I really wish there was more of this across various sections of law, because I think, especially in these high profile cases, we see a lot of companies just kind of, pay the fine, so to speak. Okay, we'll give $1.2 million for our mistake. And
we don't admit that we did anything wrong.
Exactly.
Right.
Exactly. And it feels kind of like a bribe in a way. It's like here, I'm going to pay you this and this will all just go away. And it's the way it feels. So hearing this accountability piece is it changes my perception of like what can actually be accomplished at the end of a case. It's fascinating.
This is my other big kick. I mean, Joe, you asked me earlier, and I talked about the rule of law and independence of judiciary. My other kick is trial lawyers are human beings too, right? Like we have a bad rap. And does the billboards contribute to it? Sure. Do some of the stereotypes, did LA law back in the day and Suits, I mean, does that all contribute to it? Sure. Right? And public perception. And the other thing is, right, nobody calls me because something good happened in their life. I'm not associated with happy, good, joyous things, right? They've suffered their worst tragedy when they're calling me or my colleagues. And I am amazed when I look at the membership of my association and my colleagues that they are religious leaders, they're communal leaders, they are local politicians, they are local parents, they are patients, they are students and teachers, right? They are part of the community. In Pennsylvania, we started a Beyond the Courtroom campaign where once a month we interview somebody about what they're doing outside the practice of law, the charitable work and everything that they're doing. So I think it goes back to the question I was asked earlier by Joe, which is can you get everybody on the same page? I think there's a fabric of those people who do this work consistently, who, nobody's going to sit here and look you straight in the face and say, when I earn a fee, it's a bad thing, right? I mean, and by the way, I don't see my friends at big law firms when they close a $2 billion deal and they get this huge fee saying earning a fee was a bad, wrong thing, right? You work hard, you put in your creativity and you do what you have to do. But I think the other piece is, I think by nature, trial lawyers, what we do, what we have to prove, what we have to accomplish, right? It fits that mold. And I think those personality traits, we need to be more creative in how we use them to advocate for our client beyond the release and the check.
A thing that I'm very interested about how you position all of this is, and talk about it, is so much of what you're doing, like obviously there's the in-court, the case handling, the case management, the case assessment. There's the practice of law that we were talking about from the jump. But then there's the things outside it, right? Like the larger political spectrum, what's going on nationally, what's going on across the state. What about more personally? I mean, you deal with catastrophic injury victims, and I'm wondering, you've been doing this for a while, what is the personal effect there? I mean, has it changed, for example, your own personal relationship with something like mortality? Does it change the way that you, I don't know what your family situation is, but if you have children, does it change the way you engage with them? Does it change things on a sort of larger non-legal spectrum for you?
Yeah, well, like I'm 18 years old and look how aged I am already. But anybody who does this for a long period of time, if it doesn't change them, that they're probably not in the right business or they're not doing well. So there's a couple pieces to it, right? Number one, I meet people when the worst thing in their life has happened to them for the most part. And so you're not seeing people at their best. You're also seeing them at their most vulnerable. I think, I've read some data like the statistics and parents who end up having a child that suffers major trauma, whether it's brain injury or whatever, like the rate of divorce is like 80, 90%. I see people at a point in their lives when all the dysfunction comes out, right? So in a really crude sense, I kid sometimes, it kind of makes you feel a little better about yourself. Like, as messed up as I thought I was, right? But God forbid a tragedy happens, maybe I can prove I'm more messed up. I don't know. But it's a perspective into human nature. I've had to learn both academically through coursework and personally, what grief really is, how it works, how it differs, how to communicate with people in different stages of problems. I've also, it can be very depressing at times. Although when you're up at 3 a.m. doing the work, right, it's very easy to get motivated for such worthy people. It makes it easier to go the extra 10 miles, not just 1 mile. But the other piece is, probably about halfway through my career, I finally realized that I could internalize as I was all of this and be terribly upset about all this tragedy around me that you see nonstop. I mean, you see it in criminal defense, all the families that are ruined on both sides, right? Your client, may or may not have made a mistake, and the victims and everybody else. But the other side is, we can get so caught up in all the other nonsense of daily life, sometimes referred to as first world problems, right? And one thing every one of my clients does is force me to remember perspective, and try and, when I do go home with my kids or my wife, try and remember what really is important. Because boy, we can get caught up in the lawyer battles. We can get caught up in materialism. We can get caught up in notoriety and headlines and social media and all this other stuff. But, when there are people just struggling to get through a day, like without having debilitating pain or being unable to feed themselves, or not be embarrassed about having to go outside, it can be an empowering gift.
Eric, we've spoken a lot about having a good team and really showing up for the cases yourself. With the rise of technology, do you see better advocacy for your clients? Do you see them being more empowered to actually go to trial? Do you see technology actually improving the world of malpractice?
But yes and no. Typical lawyer answer. It has increased the rate of malpractice, I truly believe. So I sit on the Pennsylvania Patient Safety Authority. I'm one of the directors appointed by the legislature. We have the largest database of events, everything from near misses to serious events in the country. We get 300,000 to 400,000 reports a year, right? And at least from my perspective, I'm not speaking on behalf of the Patient Safety Authority, but from my perspective, the rate of medical error is continuing to increase, and technology is a big factor. The electronic medical chart, right? Yeah, I can read everything now as opposed to sloppy handwriting, but healthcare practitioners aren't talking to each other anymore. They're communicating in checkboxes and putting notes in places they don't belong because there wasn't a space for them, and the volumes of problems. I mean, I could talk about that for hours, but on my side, I'm still a small firm, we're growing, but the only way I can continue to punch above my weight class is by leveraging technology. And I'm not talking about AI writing my briefs, but, there are a lot of resources who can help speed things up. I know this is sponsored by Steno. Steno has this unbelievable technology called Transcript Genius, where I can put in transcripts from a case and I can have a whole discussion. Show me where inconsistencies are. That's easy. But tell me all the references where this medication was used and what they did to look at the outcomes. And you can see the difference when you line up the transcripts with each other and then you upload some of the pleadings and stuff. It is just, the amount of time to condense the information and focus in on key topics. It used to be so important when experts were preparing their reports, I find I can be so much more efficient and laser focused, especially when I get to trial. Where was those 2 or 3 questions where they committed to this? And it's so powerful.
Eric, are you sort of glad? Obviously, you're glad to have that technology now. Are you glad that you learned how to practice law without that technology?
Yeah. Well, like, what am I going to say? Right. I learned how to drive a stick shift too. Right. But I don't know any other way. Right. I know when I was a young associate and I was at the big firm and they had somebody who would actually go down to the courthouse and file stuff. I was the guy that said, take me with you. I want to learn how in case I have to do it, which I ultimately did one day. Right. So, my daughter, who's now a young ADA, went to law school, and I kid her, she wouldn't know how to find a case in a book if her life depended on it, right? Whereas we had to, right? We were right at the beginning of Lexis and Westlaw and everything. So I don't know. Has it influenced kind of how I practice, how I approach things, how I do things? Sure. Can I look at some of the younger folks coming up who don't even think about it in the 2 dimensions I might, and they're thinking about in 4 dimensions? I got to keep my mind open to that.
Very well said. The world's changing very fast. So we're going to continue seeing this change and people adapting. And Eric, we always ask this question at the end of our conversation, and that is, what is your hottest take on the industry right now?
So, I've kind of been a student of watching the business of law from the sidelines, because I was never really in any leadership of big law. But I do see some common things going on there as well as in our bar, both locally and national, statewide and nationally. I think consolidation is going to continue. I think the cost of delivering services, in a non-government format like Joe sees a lot, it just keeps escalating. Everything from just health insurance going up and everything else. So I think the economies of scale are going to have to rule. I don't know what's going to happen if we're left with 5 big firms, what is everybody going to do about all the conflicts? But that's not kind of my segment. So I think consolidation is going to continue. I think you're going to see a continued political assault on lawsuit funding. I think that's a really hot topic. I think large certain groups want to follow the money. If they take the money out, and that's everything from multi-gazillion dollar patent cases to personal injury cases. It's not just unique to one area of litigation. I also think you're finally, if I'm a guessing man from the outside, the pressures are getting such, you're going to see a dilution of the rules of who can own law firms and share in the profits. And it'll be very interesting to see what happens with that. We saw what happened in banking is that kind of got deregulated. We saw what happened with the big 6 and the big 4 in the accounting world as that kind of ownership opportunity spread out and that was relaxed. I think that's a big trend. And I think the final big trend in my micro world of being a personal injury trial attorney is, while we are not seeing an increase in the rate of plaintiffs' verdicts nationally, we are seeing an increase in the magnitude of the verdict when it is a catastrophic injury. And tort reformers want to blame that on all sorts of evils in society. We trial lawyers are magical. We have dust and we blow it over the jury and they lose their minds because, something, right, which is not what happens. But it is causing seismic shifts in the insurance industry and big self-insured entities, pharma and everything else, to try and start addressing this. One of the queries I always ask is, well, if a case with these injuries was worth the same for 20 years, isn't it time? And are we due some past inflation, right? So, just as an aside, one of the topics I'm facing right now is the complaint over these big verdicts in medical malpractice cases. And what people don't realize is usually the largest number in those verdicts is the future healthcare costs. And it's not the plaintiff's lawyers or the victims who are setting the costs. It's the hospitals, oftentimes who cause the injury, who then charge so much to care for people who suffered that injury. But somehow, because their prices are going up, which raises the amount that a victim needs, which raises the amount of a verdict, somehow the victim should get penalized for that. So that's going to be a blossoming topic you're going to see, I think, and we're starting to see it in legislatures all across the United States.
That's a hot take indeed, Eric. I don't think we've had one like that before, Adrian. I don't know.
No, it was a fantastic hot take.
It's great. And with that, I would just like to thank everyone for tuning in to Between the Briefs, and a big thank you to Eric Weitz for sharing his valuable insights today. It's been a great conversation, Eric. Much appreciated.
Well, thank you, guys.
Of course. It's been a great discussion. And don't forget to subscribe so you never miss an episode. And we'll catch you on the next one. Take care. Up next on Between the Briefs.
I think in many ways it's overhyped, and particularly right now, there's a lot of FOMO going on, which is a little unusual for the legal community. Lawyers and legal professionals are usually pretty slow to adopt technology or to be excited about technology, but they seem to be sort of at least saying that they're going overboard, or seeming to go overboard. That's what their statements indicate. Whether they are or not, that's a different issue, which we can come back to. I think part of the problem is there are a lot of the risks with AI in the legal tech community are being ignored.
Stay tuned for the full interview coming to you soon. Between the Briefs is brought to you by Steno. To find out more about Steno and how we combine exceptional court reporting and litigation support services to deliver a superior litigation experience, visit steno.com. That's STENO.com. And then make sure to search for Between the Briefs in Apple Podcasts, Spotify, or anywhere else you get your podcasts, and click subscribe so you don't miss any future episodes. On behalf of the team here at Steno, thanks for listening.